Welcome you all to yet another session hosted by Wednesday Club on the topic Appreciation of Evidence. Appreciation of evidence means assessing the worth, quality, and value of a particular piece of evidence. It is not just a reproduction of facts or testimony, but a systematic and scientific evaluation of a material placed before the court. The of a judgment ultimately marshalling and appreciation of evidence. A goal is to carefully examine the reliability, probability, and credibility of an evidence so as to arrive at a just and recent conclusion. In this context, the words of Justice Benjamin N. Cardoso are particularly inspiring. The judge, even when he is free, is still not wholly free. He is not to innovate at pleasure. He is to exercise a discretion informed by tradition, methodized by analogy, disciplined by system, and subordinated to the primordial necessity of order social life. This court beautifully captures the essence of evidence appreciation, that judicial discretion must always be guided by reason, experience, and settled principles of law. With this thought, let us begin today's enlightening session on appreciation of evidence hosted by the Wednesday Club. To formally commence today's program, I invite Advocate Peeyus A, Kottam, sir, President of Kerala High Court Advocates Association, to deliver the welcome address.
Good evening, Wednesday Club members, Honorable Just.Jobin Sebastian, Vice President Vinay, committee members, senior counsels, my dear friends. Today we literally be honored to get a profound speaker, Just.Jobin Sebastin, to speak about principles of appreciation evidence. He practiced a lot in the trial side, and he is the best person to educate you what is the principles of appreciation of evidence. Sir, we are eagerly waiting to listen to you, so I am not spoiling the time. Sir, please.
Before that, sir, there's an announcement. So as part of today's criminal law lecture series, Wednesday Club has prepared a set of research notes on today's topic by our research team. So the link will be sent to the Wednesday Club's WhatsApp group as well as the association group. So kindly access to research notes. We have the landmark case laws and other materials. So the link will be there in the Wednesday Club association group. Thank you.
Good evening to all. The President of the Kerala High Court Advocate Association, Sri Peeyus A, Kottam, other dignitaries on and off the dais, and the coordinators and participants of this program. I take it as a privilege to inaugurate this criminal law lecture series and to lead today's session on the topic appreciation of evidence in criminal trial. Appearing in a criminal case for the accused and conducting the case for and on his behalf is not a child's play. Rather, it requires much effort, research, and dedicated study. We all are aware of the famous quote that a lawyer is supposed to live like a hermit and work like a horse. If the said quote is taken in its literal meaning, the same is not digestible. Everyone will wonder how a married lawyer can live like a hermit, and being a human being, how a lawyer can work like a horse. The wisdom behind the expression is understood. It conveys the expectation that a lawyer should lead a disciplined life and a devoted life focused on the profession. Like every individual, lawyers also have personal lives, family responsibilities, and human limitations. So time management is an essential trait that a lawyer must possess. After all, we are all living to enjoy this world and to lead a happy life. So in the midst of busy professional life, we have to find valuable time to spend with the family, colleagues, and relatives. While dealing with criminal case, a lawyer has to figure out the evidence which the prosecution proposes to rely on and how to assail that evidence. A leading writer, Shiv Khera, in his book How to Win, quoted that a winner finds a solution for every problems and a loser finds a problem in every solution. So a successful lawyer finds a solution in every problem, but a lawyer who fails finds a problem in every solution. Likewise, communication skill is an important trait that a lawyer must possess. He must be quick in answering the queries put by the court, and while cross-examining a witness, he must be capable of taking a U-turn if required, or to shape a defense within seconds by putting a suggestion after getting the answer from the mouth of a witness during cross-examination itself. I am inviting you to a courtroom incident where a brilliant lawyer succeeded in obtaining an order in favor of his party while arguing a bail application. The episode happened in Karnataka High Court. An accused was charged for the offence that he propagated extreme Maoist ideas among the tribal people. Several offences, apart from the IPC offences, several offences under UAPA Act were also slapped against him. While the bail application was arguing, the learned counsel who appeared for the accused invited the court's attention mainly on the period of incarceration which he had already undergone. The lawyer started his argument by highlighting that, "Your Lordship, please see, my client is in custody for the last around 1 decade. Without the trial of his case has been commenced." Hearing the same, and he also stick on the highlighting the long period of judicial incarceration. He stick on Article 21 of the Constitution, which speaks about the personal liberty of a person. Then the judge put a query to the lawyer. "You see, Mr. Lawyer, Mr. Counsel, you please see, your party is a Maoist having no faith in the Indian Constitution. Then how can you sought shelter under Article 21 of the Indian Constitution to get bail or to argue for bail in favor of your client?" Then suddenly the lawyer replied with an answer. "Your Lordship, unlike other religious testaments, Indian Constitution is applicable to all. The question whether they have faith in it or not, or whether they follow it or not, is immaterial or inconsequential. So I am testing your Lordship's faith in the Constitution and I am not sticking on my party's faith in the Indian Constitution. Then, impressed by the argument, the court ordered bail granted. So, this is the communication skill a lawyer should profess to get good orders. Because quick reply, sharp reply, with a soft smile will certainly conquer the mind of a judge, no doubt. Likewise, I am of the view that most of the judges are impressed by energetic arguments of the youngsters. In my experience also, it is my experience as a lawyer as well as a judge. Today's topic, which we are mainly dealing with, is the evaluation of evidence. Before entering into the topic, it is very sorry to say that among the juniors, 50% of juniors conducting trial before the trial court does not know how to contradict a witness, how to prove a contradiction, how to prove an omission, what is the relevance of an omission. While conducting cross-examination, as all of you know, the most effective weapon for a criminal lawyer is cross-examination. So, without knowing how to contradict a witness, a lawyer cannot, he is not supposed to conduct a case for the defense. Because the most precious statement which would be given by a witness after the commission of the offence certainly would be the statement firstly given before the police. Thereafter, he will get ample opportunity to consult with a lawyer. He will deliberate with the colleagues and companions. So, he will give. There is every chance of giving an improved version when he got examined before the court. So, when an improvement is made during examination before court, the said improvement has to be proved, or contradictory statement made before the police and the court has to be proved in accordance with the law. But number of juniors attending in serious criminal cases, including 302 cases, even does not know how to contradict a witness. Before entering into the contradictions, I will invite your attention to the classes of witnesses which we can find from the Indian Evidence Act. The main classifications are hostile witness. One of the class of the witnesses is hostile witness, another is chance witness, another is related witness, interested witnesses, etc. There is another class also, they are called very over-smart witnesses. So, a lawyer has to handle all these sort of witnesses. In the case of hostile witness, as all of you know, the term hostile witness is not defined under the Indian Evidence Act. But I have asked several junior lawyers to explain who is a hostile witness. But most of them stated that hostile witness is a person who gives evidence against the 161 statement which he had given to the police during the course of the investigation. Is it correct? Is it correct? Anybody can answer. Who is a hostile witness? A hostile witness is a witness who gives evidence against the statement which he had given before the police. Is it correct? Anybody can answer. A hostile witness is not a person who gives evidence, not only the person who gives evidence against a 161 statement. A hostile witness is a witness who gives evidence against the party who called him as a witness. Because, for example, when prosecution is calling a witness, if he gives evidence against the prosecution, he is a hostile witness. Most probably, when his hostility will be established, when he gave a statement against the 161 statement which he had given to the police. But you see, I am a defense lawyer, I am summoning a witness to prove my case, defense case. But during the course of the examination, during chief examination, in the defense examination stage, chief examination has to be conducted by the accuser's counsel. After beginning, the accuser's counsel started the chief examination. He had shown loyalty to the prosecution. He deposed in tune with the prosecution case. But for what purpose he is called? for proving the case of the defense. So he is also a hostile witness. Then what is the remedy? If a defense counsel calls a witness for examination and he gives in support of the prosecution case, what is the remedy? Can the defense counsel seek the permission of the court to declare him as a hostile witness? Because leading question, are you aware about leading questions? Leading questions are prohibited. Leading questions can be asked only during the course of the cross-examination. So, when a witness who is called by a party turned hostile to him, what is the remedy? He has to seek the permission of the court to cross-examine him, to put questions that were usually asked at the stage of cross-examination. When prosecution, then we can ask leading question to him. We can put suggestions to him. Leading question means a question which conveys an answer in it. Are you Leela? It is a leading question. But leading question can be asked with respect to introductory matters. So, a hostile witness means a witness who gives evidence against the party who called him as a witness. And in such a situation, a hostile witness can be questioned with the aid of section 154 of the Indian Evidence Act. The trial lawyer has to ask the court permission to put questions as provided under section 154 of the Indian Evidence Act. I may be permitted to put questions under section 154 of Indian Evidence Act. Then he can ask any questions. So that is a wrong notion. Hostile witness is a witness who gives evidence under section 161 of CRPC. Moreover, a witness for the prosecution, for example, apart from the witness cited in the charge sheet, apart from a witness who is interrogated and whose statement is recorded under section 161, can be examined by prosecution. If he is turning hostile, he can be declared hostile. He can be questioned. He can be cross-examined in terms of 154 of Indian Evidence Act, because there is no statement for him, although he is examined for prosecution. So that is a wrong notion. Now the evidentiary value of a hostile witness has been dealt by the Supreme Court by a series of judicial pronouncements. It is no longer res integra that a hostile witness evidence need not be eschewed in toto. The court can shift grain from chaff. From where we will find it? You please go through 154 of the Indian Evidence Act. It is a very important section. 154 of the Indian Evidence Act gives power to the party to put questions in the nature of the questions that can be put during the course of cross-examination. 154. When a witness turns hostile, the prosecution as well as the defense have the power to seek power to seek permission of the court to put questions under section 154 of Indian Evidence Act. 154 of Indian Evidence Act. Question by party to his own witness. The court may, in its discretion, permit the person who calls a witness to put any question to him which might be put in cross-examination by the adverse party. Any question. Next clause is very important. 154(2). Nothing in this section shall disentitle the person so permitted under subsection 1 to rely on any part of the evidence of such a witness. So a prosecution is declaring and putting questions under section, declaring him as hostile, and he is permitted, court permits him to put questions to the party merely because of that reason his evidence need not be rejected. 154(2) ആണെന്ന് പറയുന്നത്. That is not a judge-made law. It found a place in the statute itself. So, regarding hostile witness, I am concluding. Now, another set of witness is interested witness. Who is an interested witness? Now, by a category of judicial pronouncement, it is no longer res integra that interested witnesses are witnesses who are having a special interest in the outcome of this suit or outcome of the matter, outcome of this case. However, when an incident is happening inside the four confines of a house, a husband was attacked, naturally who would be the witness? the wife and children, the inmates. If the incident occurs in a wee hours, where all family members were expected to be inside the house, not at working time, the inmates in the house are natural witnesses. They may have some interest, because they may have some interest in seeing that the accused is convicted. So they were having an interest. But that does not means that they were not reliable witnesses. Because relationship is not a criterion to discard an evidence. Friendship or relationship is not a criterion to discard an evidence. If the presence of relative witnesses or friends is natural at the time of occurrence of the incident, they are treated as natural witnesses. So convincing reason is necessary to discard their evidence. Full stop. However, it cannot be ignored that while analyzing the evidence of a relative witness, court must act with some kind of much circumspection and care. Because in the case of a relative witness, I have already stated that they were having a tendency to see that the accused is convicted. That is quite natural. But if they are having a special interest due to prior animosity or existing dispute, their evidence has to be considered with much care. If the entire family and family members were having existing civil dispute or previous criminal case, etc., chance of false implication cannot be ruled out. So court has to rely upon some corroboration. Corroboration means not corroboration by other independent evidence, the evidence of neighbors, etc. Because if an incident is happening inside a house in wee hours, it is not prudent to expect that neighbors will see the incident. Moreover, now in our present societal setup, the neighbors are also not interested to interfere in others' matters. Even if they were seeing the incident, they were showing hostility to the prosecution for reasons only better known to them. So we cannot expect evidence from neighborhood in the case of brutal attack, even in cases of brutal attack. But when there is medical evidence to substantiate the evidence of a witness, compelling reason is required to discard their evidence. Like another class of witnesses injured witness. In the case of injured witness, it is settled that an injured witness comes with a built-in guarantee of his presence at the crime scene, and in normal course he will not point his finger towards or implicate an innocent person in the crime. Why? Why? Because by pointing his finger to an innocent person, the actual assailant or accused is going to be left unpunished. So no person with ordinary prudence will take such a risk. If I am attacked by a person in a brutal manner, I will not point to an innocent person, because it will afford an opportunity to the actual assailant to escape punishment. So the evidence of a injured witness is accorded a special status in law. But moreover, there are cases in which some tactful parties who will self-inflict some minor injuries to escape from the punishment, to see that the accused is convicted, if he is having any previous score or any acts to grind against the accused. So the nature of the injury, the medical evidence, etc., also has to be considered in conjunction with the evidence of the injured witness while appreciating the evidence. So there is no inflexible rule that in the case of an injured witness, the solitary evidence of injured witness shall form basis for conviction invariably in all cases. But the court has to analyze various facts such as chance of false implication, nature of the injuries, whether the injuries can be self-inflicted, is there any previous dispute between the parties, whether the de facto complainant the injured is having any reason to falsely implicate him, etc. So there is no inflexible rule in appreciation of evidence. Likewise, another class of witnesses that I classify intelligent witnesses, over-smart witnesses, that we could not find from the Evidence Act. That is from my experience. For example, when we are asking a question, he is taking it as a privilege, proud, I am very intelligent, he will come to the box, witness. And when a counsel is asking a question, how did you see the incident? Then he will answer. with my eyes. With my eyes. It will certainly provoke a lawyer with a normal temperament. It will provoke a lawyer. But the intelligent lawyer will put a question, oh, I think that you saw it with your ears. So those witnesses have to be handled with very care and sharpness. Some witnesses will give a vivid account of the incident during chief examination. But when we were cross-examining him, he will say, ഞാൻ ഓർക്കുന്നില്ല, I am not remembering. ഞാൻ ഓർക്കുന്നില്ല, എന്ത് ചോദ്യം ചോദിച്ചാലും ഞാൻ ഓർക്കുന്നില്ല. അങ്ങനെയുള്ള സാക്ഷികളെയൊക്കെ കൈകാര്യം ചെയ്യുമ്പോഴാണ് നമ്മുടെ ടെമ്പർമെൻറ്റ് പോകും. അപ്പോൾ അവരോട് ക്രോസ് ചെയ്യുന്നതൊക്കെ വളരെ ശാസ്ത്രീയമായിട്ട് ചോദിക്കുന്നത് നമ്മൾ പഠിക്കണമെങ്കിൽ we have to attend the cross-examination of senior lawyers by sitting in trial courts after noon. Cross-examination is likewise, you see, I will explain an incident. In a murder case, in the recent years, in the recent times, in all cases, the intervention of media is very high. Before the incident occurs, the media will came to the place of occurrence. For breaking news, they will came. And the investigating officers and media maniac police officers will give interview. And bites. In one case, a person was attacked brutally and 38 injuries were inflicted upon him. His brother was also with him. It was in the night, the attack was in the night. And following the attack, the main injured died on the spot. The elder brother died on the spot. The younger brother who accompanied him also sustained some minor injuries. Fortunately, he did not die. After the incident, the dead body was taken to the hospital. After examining, the doctor reported dead. He is dead. And then the media persons approached the injured. Media persons asked some questions to the injured witness. Then he said, when the incident was occurred, it was around 8:15 p.m. Due to heavy rain, I could not recognize the assailants. Before the media personals. Trial started. Trial of the case started. His 161 statement was recorded. His FIS was recorded. On the strength of his FIS, case was registered. In the FIS, he had named the names of all the assailants. With the names, his FIS. And during trial, he stick on the FIS. And at the time of trial, he stated that I saw each and every witness from the crime scene itself. And this is the first accused who hacked him a sword. This is the accused who hacked him, hit him like with a knuckle duster, etc., etc. All the weapons were also identified. Then the defense counsel intended to prove the bite given to a particular channel. The head of the department was also called. Then the head of the department, we will keep the bite only for 3 months. So fortunately, it could not be proved. Now the question to be considered is whether under which provision of the Indian Evidence Act the said bite can be proved. It is only a oral statement. It is not a former written statement. Which is the provision which enables a trial lawyer to prove that statement? He didn't. You see, if there is a written statement, we can impeach his credit by saying that, have you questioned by the police? Yes. When you were questioned, have you given such a statement? That it was night, I have no prior acquaintance with him, so I could not recognize the assailants. അങ്ങനെ നിങ്ങൾ പറഞ്ഞു കൊടുത്തോ നമുക്ക് ചോദിക്കാം അല്ലേ? പോലീസിനോടത്തെ മൊഴിയിൽ നിങ്ങൾ അങ്ങനെയല്ലേ പറഞ്ഞതെന്ന് ചോദിച്ചാണ് നമ്മൾ കോൺക്രെഡിറ്റ് ചെയ്യുന്നത്. Provision is under section 145 of Indian Evidence Act. 140. You please go to 145 of Indian Evidence Act. A witness may be cross-examined as to previous statement made by him in writing or reduced into writing and relevant to matters in question without such writing being shown to him or being proved. But if it is intended to contradict him by the writing, his attention must, before the writing can be proved, be called to those parts of it which are to be used for the purpose of contradicting him. So when there is a written statement, we can invite his attention. You see, you have given a statement otherwise. And thereafter, when the investigating officer is in the box, we can ask, ഇരുട്ടായതുകൊണ്ടും മുൻപരിചയമില്ലാത്തതുകൊണ്ടും പ്രതികളെ എനിക്ക് തിരിച്ചറിയാൻ സാധിക്കില്ല എന്ന് മൊഴി നൽകിയിട്ടില്ലേ? ദെൻ ഇൻവെസ്റ്റിഗേറ്റിംഗ് ഓഫീസർ എന്ന് പറയും, അങ്ങനെ നൽകിയിട്ടുണ്ട്. അവൻ ഡിനൈ ചെയ്താൽ അഡ്മിറ്റ് ചെയ്താൽ പിന്നെ ഇൻവെസ്റ്റിഗേറ്റിംഗ് ഓഫീസറോട് പുട്ട് ചെയ്യേണ്ട. അങ്ങനെയാണ് കോൺട്രഡിക്ഷൻ പോവുകയെന്ന്, ഒമിഷൻസും. അങ്ങനെ പറഞ്ഞു കഴിയുമ്പോഴത്തേക്കും അങ്ങനെ പറഞ്ഞു തന്നിട്ടുണ്ടെന്ന് പറഞ്ഞാൽ ദാറ്റ് കോൺട്രഡിക്ഷൻ സ്റ്റാൻഡ്സ് പ്രൂവ്ഡ്. പക്ഷേ ഇതിൽ നോ റിട്ടൺ സ്റ്റേറ്റ്മെൻറ്റ്. ദിസ് ഈസ് എ ബൈറ്റ് ഗിവൺ ടു എ മീഡിയ പേഴ്സൺ. ഹൗ ക്യാൻ ഇറ്റ് ബി പ്രൂവ്ഡ്? വിച്ച് ഈസ് ദ പ്രൊവിഷൻ എനേബിൾ you to prove? You please go through 155(3) of the Indian Evidence Act. 155 of the Indian Evidence Act. The credit of a witness may be impeached in the following ways: by the adverse party or with the consent of the court by the party who calls him. By the evidence of a person who testify that they from their knowledge of the witness believe him to be unworthy of credit. ഒരു സാക്ഷിയെ കൊണ്ടെന്ന് പറയുക ഇവൻ വിശ്വസിക്കാൻ കൊള്ളാത്തവനാണെന്ന് പറയിപ്പിക്കാം. 2, by proof that the witness has been bribed. അതുകൊണ്ടാണ് ചില കൊലക്കേസുകളിലൊക്കെ വാദിക്കുമ്പോൾ ചോദിക്കുന്നത്, കൂറുമാറി കഴിയുമ്പോൾ പ്രോസിക്യൂട്ടർ ചോദിക്കും, നിങ്ങൾ ഇന്ന് ഈ കോടതിയിൽ സാക്ഷി പറയാനായി വന്നത് ഈ കേസിൽ, നോക്കൂ സാക്ഷി, നിങ്ങൾ ഇന്ന് ഈ കേസിൽ മൊഴി പറയാനായി വന്നത് പ്രതിയോടൊപ്പമല്ലേ? അതെ. നിങ്ങൾ ഇന്ന ബസ്സിൽ കയറി, നിങ്ങൾ ഇന്ന ബസ്സിൽ തൊടുപുഴ പാലാ ബസ്സിൽ കയറി, പാലാ കോടതിയിൽ നിങ്ങൾ ഇറങ്ങിയില്ലേ? ഇറങ്ങി. ആ ബസ് സ്റ്റോപ്പിൽ ഒരു ചായക്കടയില്ലേ? ചായക്കടയുണ്ട്. നിങ്ങൾ രാവിലെ അപ്പവും മുട്ടയും കഴിച്ചില്ലേ? ഒരുമിച്ചല്ലേ? അതെ. പ്രതിയല്ലേ ആ പൈസ കൊടുത്തത്? ആ ബ്രൈബാണ് അല്ലേ? അപ്പോൾ ആ ചോദ്യങ്ങൾ ചോദിക്കുന്നത് അവനെ ഇമ്പീച്ച് ചെയ്യാനാണ്, അവൻ്റെ ക്രെഡിറ്റ് തകർക്കാൻ വേണ്ടിയാണ് ചോദിക്കുന്നത് ആ ചോദ്യങ്ങൾ. അതുപോലെ തന്നെ എനിക്കും സംശയമുള്ള ഒരു ഏരിയയാണ്, ചിലയിടത്ത് ചോദിക്കും നിങ്ങൾ 36 ക്രിമിനൽ കേസിൽ പ്രതിയല്ലേ സാക്ഷിയോട് ചോദിക്കുന്നത്. അപ്പോൾ ക്യാരക്ടർ ഓഫ് എ പാർട്ടി ഈസ് ഇറലവൻറ്റ് ഇൻ ക്രിമിനൽ പ്രോസിക്യൂഷൻ എന്ന് പറഞ്ഞിട്ടുണ്ട്, എക്സെപ്ഷൻ ഉണ്ടെങ്കിൽ പോലും. പക്ഷേ ഈ 155(3) പറയുന്നത് അങ്ങനെയല്ല. By the evidence of a person who testified that they from their knowledge of the witness believe him to be unworthy of credit. അതിനുശേഷം മൂന്നാമത്തേതാണ് നമ്മുടെ കേസിൽ ഉപകാരം വരുന്നത്. By proof of former statements inconsistent with any part of his evidence which is liable to be contradicted. അപ്പോൾ ആ ബൈറ്റ് കൊടുത്ത് പ്രൂവ് ചെയ്യാം. ഫോർമർ സ്റ്റേറ്റ്മെൻറ്റ്, നോ ഫർദർ ക്വാളിഫിക്കേഷൻ ഇസ് റിക്വയർഡ്, ഓൺലി ഫോർമർ സ്റ്റേറ്റ്മെൻറ്റ്, നോ റിട്ടൺ സ്റ്റേറ്റ്മെൻറ്റ് ഈസ് റിക്വയർഡ്. സോ വിത്ത് ദി എയ്ഡ് ഓഫ് 155(3) he can be asked, have you given a bite to in a channel, Asianet or Reporter channel, to that effect. That is another thing. Then dying declaration. Regarding dying declaration also, the juniors are a little bit confused, because section 32 of the Indian Evidence Act says that certain statements are relevant. The condition is that statements can be used if the person who made the statement is dead, who is incapable to give evidence, or his protection is highly expensive, which the court considers to be not tallying with the relevance of the evidence which he had to give. So a statement made by a person regarding the cause of his death or circumstances of transaction which resulted in his death is relevant under section 32. Regarding the cause of death or circumstances of transaction which resulted in his death is relevant under section 32 when the cause of death comes into question. അതാണ് section 32 പറയുന്നത്. A young girl was raped. After 3 years of the incident, she died in a motor accident. So prior to the trial, at the time of trial, he could not be procured because she is dead. Whether the statement in the rape case, her statement was sought to be proved. Statement given before the police at the time of registration, FIS, was sought to be proved as a dying declaration. Is it legally permissible? She is no more. Accused is facing prosecution for rape. She subsequently died in a motor accident. Oh, simple. 376 Vitale. In a 323 matter, you were beaten by a party. I was beaten by a party. Subsequently, offence under section 323 was registered on the strength of my statement. And at the time of 323 case, offence under trial of 323 case, I was no more. Then whether the statement given by me before the doctor as well as before the police can be used as a dying declaration? Can it be used as a primary evidence? Why? Why? Because cause of death is not in question. Only when the question is who killed him, who abetted the suicide of that lady, who committed culpable homicide, cause of question is there. Cause of death is in question. So here cause of death is not in question. Has this guy voluntarily caused hurt on him? That is the question in 323 matters. Whether the accused ravished her, that is the question. So in those circumstances, it is not a dying declaration. Only when the cause of death is in question. As per Indian law, I think that you all were aware, it is not a necessity that at the time of giving the dying declaration, the declarant was expecting death. At India, expectation of death is not necessary. But recently I also, while handling with the case, I also met with another situation where a lady committed suicide following the ordeals and following the harassments and ill-treatments in her matrimonial home. The accused, the husband as well as her in-laws were charged for the offences punished under section 306 of IPC and 498A of IPC. Abetment to commit suicide, and 498A, as you know, husband or relatives of the husband subjecting the women to cruelty. During trial, the main evidence relied on by the prosecution was the letter written by the lady to her father and messages sent by her to her father explaining the ordeal, explaining the trauma and ordeal she faced. That was the main piece of evidence. Anyhow, trial court found that offence under 306 IPC is not made out because the necessary mens rea to constitute such an offence is wanting in that case. Hence, the accused was all the accused were acquitted under section 306 IPC but convicted under section 498 IPC. Subsequently, the accused took the matter in appeal, challenging the judgment of conviction under 498A. They took the matter in appeal. Now, the question that arose in the appeal, the main question that arose for consideration was whether in the appeal, the statement and messages, the letter sent by the daughter to the father and the messages sent by the daughter to the father can be used as a dying declaration. When the matter was before the trial court, offence under section 306 was also there. So question of death was also was an issue. Whether the accused abetted the suicide of that lady. That is one of the main issue. But he was acquitted. In the appellate court question, there is no question regarding cause of death. So I was under the impression that it cannot be used because cause of death is not in question. He is acquitted. Appellate court, we are not dealing with the question of 306. We are only dealing with the question whether there is sufficient ground to interfere with the judgment passed for offence for conviction of judgment of conviction passed for offence under section 498A of IPC. But on searching the judgments, I found that there is a full bench decision of the Supreme Court which says that in 498 matters also the statement of the witness can be used if in the original at the appellate stage as a dying declaration, if there was a charge under section 306 at the time of original trial, charge ഉണ്ടെങ്കിൽ 498 ഉപയോഗിക്കാമെന്ന് പറഞ്ഞു. അപ്പം the law is always flexible. അപ്പം ഈ ഡെവലപ്മെൻറ്റ്സ് നമ്മൾ അറിഞ്ഞിരിക്കണം. We must be aware about all those developments. Now another important topic under the Indian Evidence Act is res gestae. I think section 6 of the Indian Evidence Act mainly deals with res gestae. Res gestae says that matters forming, facts forming part of the same transaction are relevant. Facts forming part of the same transaction are relevant. A is tried for the murder of B by beating him with a club with the intention of causing his death. I will give you a small illustration. A beats B with a stick. Whatever is said by A at the time of beating and whatever is said by B at the time of beating, whatever is said by the bystanders of beating, if heard by a third party and deposed before the court, that is a part of the same transaction. So it is not hit by section 60 of the Indian Evidence Act, which says that oral evidence must be direct. Section 60 of the Indian Evidence Act says that if it refers to a fact which can be seen, it must be the evidence of the person who saw it. If it is with respect to a fact which can be heard, it must be the evidence of the person who heard it. If it is with respect to a fact which can be perceived by senses, it must be the evidence of the person who actually perceived it by his own senses. That is the principle of direct evidence. But rest just a ഒരു സംഭവം നടക്കുമ്പോഴത്തേക്കും ഒരു സംഭവം അവിടെ നടക്കുന്നു. അപ്പം അയ്യോ ജോബിനെ അവനെ തല്ലാതെ എന്നൊരാൾ പറയുകയാണ്. അത് വേറെ ഒരാൾ ഓവർഹിയർ ചെയ്യുക. അത് റെസ്റ്റ് ജസ്റ്റയാണ്. ബിക്കോസ് അട്രൻസ് ഈസ് കണ്ടംപറേനിയസ് വിത്ത് ദി ഇൻസിഡൻറ്റ്. വൈ റെസ്റ്റ് ജസ്റ്റേക്ക് എന്തുകൊണ്ടാണ് പ്രാധാന്യം കൊടുക്കുന്നത്? ആ അട്രൻസ് നടത്തുന്ന ആൾക്ക് വിൽ നോട്ട് ഗെറ്റ് ടൈം ടു ഫാൾസിഫൈ ദ മാറ്റേഴ്സ്, കോൺഗോട്ട് ദ മാറ്റേഴ്സ്. ഇപ്പോൾ എന്നെ വിനയ് തല്ലുകയാണെങ്കിൽ അയ്യോ വിനയ് എന്നെ തല്ലല്ലേ എന്ന് ഞാൻ പറയുള്ളൂ. ആ തല്ലുന്നതിൻ്റെ കൂടെ ആ കണ്ടംപറേനിറ്റിയാണ് അതിന് ഗ്യാരണ്ടി കൊടുക്കുന്നത്. പക്ഷേ ഇപ്പോൾ അയ്യോ വിനയ്, എറണാകുളം ഹൈക്കോടതിയിലെ വിനയ്, ഇപ്പോൾ ഗവൺമെൻറ് പ്രീഡറായ വിനയ് എന്നെ തല്ലുന്നതെന്ന് വിളിച്ചു പറഞ്ഞു കഴിഞ്ഞാൽ അതിനകത്തൊരു ചെറിയൊരു സംശയമുണ്ട്. മനസ്സിലായില്ലേ? അല്ലെങ്കിൽ ഇന്ന നാട്ടിൽ ഇന്നയാളുള്ള ഇന്ന POയിൽ താമസിക്കുന്ന വിനയെ എന്നെ കൊല്ലല്ലേ എന്ന് പറയുമ്പോൾ തന്നെ അത് കുഴപ്പമായി അല്ലേ? അതൊക്കെ നമുക്ക് സാധാരണ കോമൺ സെൻസ് വെച്ച് കണ്ടുപിടിക്കാവുന്ന കാര്യങ്ങളാണ്. അപ്പം ആ അട്രൻസിൻ്റെ കണ്ടംപറേനിറ്റിയാണ് അതിൻ്റെ ഗ്യാരണ്ടി എന്ന് പറയുന്നത്. അപ്പം the test is whether the utterance overheard by the third party and who deposed before the court about the same was made contemporaneous with the transaction. Contemporaneous. So, however, the definition of the section 6 Justice says that form part of this same transaction. സെയിം ട്രാൻസാക്ഷൻ ഇച്ചിരി വൈഡറായിട്ട് പറഞ്ഞുകൊണ്ടൊരു റൂളിങ് കേരള ഹൈക്കോടതിയുടെ ഉണ്ട്. PB സുരേഷ് കുമാർ സാർ പറഞ്ഞൊരു റൂളിംഗ് ഉണ്ട്. അത് എല്ലാവരും ഒന്ന് വായിച്ച് നോക്കണം. എനിക്കതൊന്ന് വായിക്കാൻ പറ്റിയില്ല. സെയിം ട്രാൻസാക്ഷൻ ഇച്ചിരി വൈഡർ ടൈമിൽ പറഞ്ഞൊരു റൂളിംഗ് ഉണ്ട്. പക്ഷേ സാധാരണ ഇതിൻ്റെ ടെസ്റ്റ് എന്ന് പറയുന്നത് നോർമൽ ടെസ്റ്റ് ഈസ് ദാറ്റ് ഇഫ് ഇറ്റ് ഈസ് എ ഡിസ്ക്രിപ്ഷൻ ഓഫ് എ പ്രീവിയസ് ഇൻസിഡൻറ്റ്, ആഫ്റ്റർ സീയിങ് എ ഇൻസിഡൻറ്റ് ഐ റഷ് ടു ദ നെയ്ബർഹുഡ് ആഫ്റ്റർ സീയിങ് എ ഇൻസിഡൻറ്റ്, ഐ am also an injured. Then I stated to the neighbor that I was beaten by Raman. It is a description of a previous incident. That is hit by hearsay principle. അയാൾ പറയുന്നത് ഹിറ്റ് ബൈ ഹിയർസേ പ്രിൻസിപ്പിളാണ്. ബട്ട് റെസ്റ്റ് ജസ്റ്റ് ആണോ? അല്ല. കാരണം നടന്ന ഒരു സംഭവത്തെക്കുറിച്ച് ഞാൻ വേറെ ഒരാളോട് ചെന്ന് പറയുകയും ആ വേറെ ഒരാൾ കേൾക്കുകയും ചെയ്യുകയാണ്. അപ്പോൾ അയാൾ കൊടുക്കുന്ന എവിഡൻസ് എന്ന് പറയുന്നത് ഇറ്റ് ഈസ് ഹിറ്റ് ബൈ ഹിയർസേ. ദാറ്റ് ഈസ് ദ പ്രിൻസിപ്പിൾ ഓഫ് കണ്ടംപറേനിറ്റി എന്നും വേണമെങ്കിൽ പറയാം നമുക്ക് റെസ്റ്റ് ജസ്റ്റയെ സംബന്ധിച്ച്. There is another notion. You see, in criminal cases, in murder cases, like murder cases, 27 recovery. The general principle is that confession made by an accused to a police officer or while in custody is inadmissible in evidence. Confession made to a police officer while in custody or while in custody is inadmissible in evidence. Section 27 is an exception to the said principle. Section 27 says that when a fact is discovered consequent to a statement made by an accused while in custody, so much of the information which distinctly leads to the discovery of a fact alone can be proved against the accused. So much of the information which distinctly leads to the discovery of the fact alone can be proved against the accused. 27 recovery alone is not sufficient to convict an accused in 302 കേസിലുണ്ട്. Why it is so stated? 27 recovery, chance of manipulations and fabrication cannot be ruled out from the investigating officer. So in 302 cases, it is not safe to convict an accused solely on the basis of 27 recovery. But if there is convincing evidence to show that it was solely on this disclosure statement given by the accused, it is also a valuable piece of evidence. If corroborated by other evidence, it and also will give an additional strength to the prosecution case. 27 recovery. What is the fact? The fact discovered is not the knife or weapon of the offence alone. But the knowledge of the accused regarding the weapon used in the commission of the offence, place where it is concealed and the place where it is concealed. That is the fact discovered. But 27 recovery alone is sufficient to convict in a theft case. Why? Why? Presumption. That is the correct answer. Because after the commission of the offence, I was an accused was apprehended. Subsequently, he was interrogated. During the course of the interrogation, he had given a statement. On the strength of the disclosure statement and as led by the accused, the investigating officer is going to his house. And from beneath his coat, a stolen article was taken and handed over to the investigating officer. Then what is happening? The recovery is affected from the possession of the accused immediately after the commission of the offence. So, then the presumption will operate. Presumption under section 114A says that if a person is found in possession of a stolen article immediately after theft or soon after theft, he is presumed either to be the thief or receiver of stolen property. In theft cases, we cannot lay it as an abstract rule that 27 recovery alone is not sufficient to convict an accused. That is the difference in a 302 case and in a theft case. Now, one of the major mistakes committed by trial lawyers is regarding failure to prove contradictions in the 154 statement. 154 statement. Law is already set on the basis of the FIS given by an accused in a criminal case. So, 154 statement lawyers in their samshayam endaanennu choദിchal 154 statement signed statement aanu. During trial, in almost all cases, it would be marked as an exhibit. 154 statement ഒരു സാക്ഷി പറയാണ് കുത്തിയെന്നൊരു കേസ് അവനില്ല, അല്ലെങ്കിൽ ഒരു പിച്ചാത്തി കൊണ്ട് എന്നെ കുത്തി എന്ന് 154 പറഞ്ഞിരിക്കുക. He stated that I was stabbed with a knife. But during examination before court, he said that injury was not as penetrating injury. He was stabbed with the handle of a chopper, handle portion of a chopper. He stabbed me with the handle portion of a chopper. Quite contrary to his 154 statement. Anyhow, the said contradiction was not put to the witness at the time of trial. നിങ്ങൾ പോലീസിൽ മൊഴി കൊടുത്തപ്പോൾ പിച്ചാത്തിക്ക് കുത്തിയെന്നല്ലേ പറഞ്ഞതെന്ന് ചോദിക്കണ്ടേ? ചോദിച്ചില്ല. അതിനുശേഷം ഈ കേസ് വീണ്ടും ഫൈനൽ ഹിയറിങ്ങിനായിട്ട് വന്നപ്പോൾ counsel highlighted this contradiction. And the counsel said 154 statement is a signed statement. It is marked in evidence as exhibit P1. So although I have not put that question to the witness, the said contradiction can be considered. Can it be considered? What is your opinion? 154 is a signed statement. 154 bears signature of the informant. It is marked in evidence as prosecution evidence. Whether the contradiction has to be put during examination and proved while the investigating officer who recorded the FIS is in the box. What is I? Yes, പറയുന്നവർ കൈപ്പൊക്കി നമുക്ക് നോക്കാമല്ലോ ഭൂരിപക്ഷം. യെസ് പറയുന്നവർ 1, 2, 3, 4, 5, 6, 7, 8, 9. നോ പറയുന്നവരെന്ന് കൈപ്പൊക്കി. നോ പറയുന്നവർ 154. ബാക്കി കൂടുതലും ബുദ്ധിമാന്മാരാ അല്ലേ? പക്ഷെ അതിലൊരു കാര്യം എന്താണെന്ന് വെച്ചാൽ 154 is not a substantive piece of evidence. Marking of a document is for the purpose of convenience. 154 is not a substantive piece of evidence. It is a statement recorded by police. Although it bears the signature of the declarant or informant, the same is not a substantive piece of evidence. 154 can be used only for the purpose of contradiction and corroboration. But it is better than, it stands on a better footing when compared with section 161. 161 can be used only for the purpose of contradiction, but 154 can be used for the purpose of contradiction and corroboration. When it is not a substantive piece of evidence, whether lawyer can ask the court to look into that document and to decide on contradiction? No. So it cannot be used. Lawyer must specifically ask. അത് ചോദിക്കാത്തതുകൊണ്ട് അപ്പീൽ വന്ന് പല വക്കീലന്മാരും വാദിക്കും. പക്ഷെ അവരെ കുറ്റം പറഞ്ഞിട്ട് കാര്യമില്ല, കാരണം ഇത് ട്രയൽ കോർട്ടിൽ ചോദിക്കേണ്ടതായിരുന്നു. ദ ഡിഫൻസ് ലോയർ ought to have asked that question. നിങ്ങൾ പിച്ചാത്തിക്ക് കുത്തിയെന്നല്ലേ പറഞ്ഞത്, അയാൾ അഡ്മിറ്റ് ചെയ്താൽ പിന്നെ ചോദിക്കേണ്ട കാര്യമില്ല, കാരണം അഡ്മിറ്റഡ്, കോൺട്രഡിക്ഷൻ സ്റ്റാൻഡ്സ് അഡ്മിറ്റഡ് ആൻഡ് പ്രൂവ്ഡ്. Proof can be by admission also. But if it is denied when the investigating officer who recorded the statement is before the court, it is obligatory on the part of the defense counsel to prove the same by asking that whether such a statement was given to you. And the contradiction can be proved. Likewise, 164 statement is a statement recorded by a judicial officer. 164 is also a signed statement. It can be used only for the purpose of contradiction and corroboration. Is it correct? But it is recorded by a judicial officer, not by a police officer. There was a serious contradiction. ഇതുപോലെ തന്നെ ഇതേ contradiction, facts ഇത് തന്നെ പിച്ചാത്തി, മറ്റേത് വാക്കത്തി. Whether is it necessary to put that contradiction? Yes. What is your opinion? What is yes പറയുന്നത്? പുട്ട് ചെയ്യണം. നേരത്തെ വക്കീലപ്പം നോ എന്നാ പറഞ്ഞത്. പുട്ട് ചെയ്യണം 164. അതിനെ സംബന്ധിച്ച് ഡൈവേർജൻറ്റ് വ്യൂസ് ഉണ്ട്. പക്ഷെ പൊതുവെ പറയുന്നത് 164-നാണെങ്കിൽ ആ കോൺട്രഡിക്ഷൻ പുട്ട് ചെയ്യേണ്ടെന്ന് പറയുന്നു. കാരണം യു പ്ലീസ് ഗോ ത്രൂ സെക്ഷൻ 80. സെക്ഷൻ 80 ഓഫ് ദി ഇന്ത്യൻ എവിഡൻസ് ആക്ട് സേസ് ദാറ്റ് Section 80, presumption as to documents produced as a record of evidence. Whenever any document is produced before any court, purporting to be a record of memorandum of the evidence or any part of the evidence given by a witness in a judicial proceedings, or before any officer authorized by law to take such evidence, or to be a statement or confession by any prisoner or accused person taken in accordance with the law, and purporting to be signed by any judge or magistrate, or by any such officer as aforesaid, the court shall presume that the document is genuine, that any statement as to the circumstances under which it was taken, purporting to be made by the person signing it, are true, and that such evidence, statement or confession was duly taken. So a presumption under section 80 is attached with such a statement. So it is accorded a special status, unlike 154 statement. So the recent decisions of the Supreme Court says that even without examining the judicial officer, contradiction can be can be highlighted at the time of arguments. So it is not necessary. But in the case of 154, it is obligatory if you want to contradict the witness with the 154 statement, you have to resort to the proceedings mentioned under section 145 of the Indian Evidence Act. With these words, I am concluding. I hope that if you want to ask some few questions, if എനിക്ക് അറിയാവുന്നതാണെങ്കിൽ ഞാൻ പറയാം, 1 or 2 questions, otherwise we can conclude. Yes.
I have a question with that. Lord, I have a question with regard to the recent example that Lord has stated. With regard to the section 80 that you, Lord, has just mentioned, the word used is evidence.
Yes.
But is a statement given before a 164 is an evidence?
Evidence statement.
But statement is with regard to that record that have been accused, is it not? The word statement used in section 80, as a doubt, I am having a doubt that statement with the word statement used in section 80.
The decision of the Supreme Court says that the statement recorded under section 164.
Yeah.
Also how the presumption under section 80.
Only with regard to the term use I have just. Yes.
Statement of the accused.
That's it. Yes, okay.
Yes. Can be concluded. Can be concluded.
Any more questions?
Something that I'm not an expert. I'm also like you. I am also in the learning process.
FIA സ്റ്റേറ്റ്മെന്റ് പിന്നെ 145 വെച്ച് കോൺട്രഡിക്റ്റ് ചെയ്യണമെന്ന് പറഞ്ഞല്ലോ. അപ്പോൾ ബഹുമാനപ്പെട്ട കോടതി ഇപ്പോൾ പറഞ്ഞ പോലെ 155 ക്ലോസ് 3 പ്രകാരം ഫോർമൽ സ്റ്റേറ്റ്മെന്റ് ആയിട്ട് അതൊരു ഫോർമൽ സ്റ്റേറ്റ്മെന്റ് ആണല്ലോ.
Statement written statement. Being a written statement, the witness can be contradicted only by using the procedure mentioned under 145.
അത് റെക്കോർഡഡ് സ്റ്റേറ്റ്മെന്റ് ആയതുകൊണ്ടാണ് അങ്ങനെ ഉപയോഗിക്കാൻ പറ്റുന്നത്.
Writing, because it is a
same thing applies to 164.
that is an oral statement. It can be proved only by examining the person who heard the statement or recorded the statement. ഈ ക്ലോസ് ചെയ്യുമ്പോൾ വളരെ ചില ചോദ്യങ്ങൾ എഴുതിക്കൊണ്ടൊന്ന് ചെയ്യുന്നത് കേട്ടിട്ടുണ്ട്. പക്ഷേ നമ്മുടെ ടി വി പ്രഭാകരൻ സാറൊക്കെ പാലായിലും തൊടുപുഴയിലൊക്കെ വന്ന കേസ് നടന്നു കേട്ടിട്ടുണ്ട്. അതുപോലെ സുകുമാരൻ സാർ, ഞാൻ വക്കീലായിരുന്നു. അപ്പോൾ ഒരു 10-26 വർഷം മുമ്പൊക്കെ ഈ ചോദ്യങ്ങൾ തയ്യാറാക്കാതെ ഒന്നും അവർ ചോദിക്കും. കാരണം ചോദ്യങ്ങൾ തയ്യാറാക്കി വരുമ്പോൾ ഒരു കുഴപ്പം എന്താണെന്ന് ചോദിച്ചാൽ നമുക്ക് ചിലപ്പോൾ പെട്ടെന്നൊന്ന് ഷിഫ്റ്റ് ചെയ്യേണ്ടി വരും. ഫോർ എക്സാമ്പിൾ, ഒരു കേസിൽ, ഉത്തർപ്രദേശിലൊരു കേസിൽ, യുപിയിലൊരു കേസിൽ ഒരു കുട്ടിയുടെ പറ്റേണിറ്റി ഡൗട്ട് ചെയ്തൊരു ഫാദർ ഷൂട്ട് ഡൗൺ ഹിസ് സൺ ഫ്രം എ മാംഗോ ട്രീ. അവൻ മാങ്ങ കഴിച്ചുകൊണ്ടിരുന്നപ്പോൾ മകൻ്റെ പറ്റേണിറ്റി ഡൗട്ട് ചെയ്തൊരു ഫാദർ ഷൂട്ട് ഡൗൺ ഹിസ് സൺ ഫ്രം എ മാംഗോ ട്രീ. ഒരു ലോയറിൻ്റെ അടുത്ത് ചെന്നപ്പോഴത്തേക്ക് ലോയർ ചോദിച്ചു, താൻ എന്ത് പണിയാടോ കാണിച്ചത്, താൻ എന്തിനാ മകനെ വെടിവെച്ച് വന്നത്? അന്നേരത്തെ ഇവൻ പറഞ്ഞു, സാർ, ഐ വാസ് അണ്ടർ ദി ഇംപ്രഷൻ ദാറ്റ് ഇറ്റ് ഈസ് എ മങ്കി. എൻ്റെ അവിടെ കൃഷി നശിപ്പിക്കുന്നുണ്ട്, അപ്പോൾ അത് മങ്കിയാണെന്നും കൊണ്ടാണ് ഞാനിത് ചെയ്തതെന്ന് പറഞ്ഞപ്പോഴത്തേക്ക് ആ ലോയർ ചോദിച്ചു, ഡു യു തിങ്ക് ദാറ്റ് എ മങ്കി വിൽ വെയർ എ റെഡ് ഷർട്ട് എന്ന് ചോദിച്ചു. അപ്പോൾ ഈ കുട്ടി ഒരു ചുവന്ന ഷർട്ടാണ് ധരിച്ചിരുന്നത്. അപ്പം ആ ചോദ്യം ചോദിച്ചപ്പോൾ പെട്ടെന്ന് ലോയറിന് അന്നേരം ഒരു ഡിഫൻസ് ലോയർ ഷേപ്പ് ചെയ്തു. ലോയർ ഷേപ്പ് ചെയ്ത ഡിഫൻസ് എന്താണെന്ന് ചോദിച്ചാൽ, അവിടെ ഒരു ഇങ്ങനെ ഹ്യൂമൻ ആനിമൽ കോൺഫ്ലിക്റ്റും ആനിമൽ ഡിസ്റ്റർബൻസും ഡിസ്ട്രക്ഷൻ ടു അഗ്രികൾച്ചർ പ്രൊഡക്ട്സ് ഒക്കെ ഉള്ള സമയമാണ് ഈ ആനിമൽ സോയിൽ. അപ്പം ഈ സംഭവത്തിന് 2 ദിവസം മുമ്പ് ഈ കുരങ്ങ് വന്നു ഈ കുട്ടിയുടെ ചുവന്ന ഷർട്ടുമായി പോയെന്നും പിന്നീട് ഈ മരത്തിൻ്റെ കമ്പയിൽ ഈ ചുവന്ന ഷർട്ടുമായിട്ട് കുരഞ്ഞിരുന്നപ്പോൾ ഈ കുരങ്ങാണെന്നോർത്താണ് വെടിവെച്ചതെന്ന് ഡിഫൻസ് ഷേപ്പ് ചെയ്തു. അതൊക്കെ പെട്ടെന്ന് ഒരു ഡിഫൻസ് ഷേപ്പ് ചെയ്യുകയാണ്. എന്ന് പറഞ്ഞാൽ നമ്മൾ ക്രോസ് എക്സാമിൻ ചെയ്ത് വരുമ്പോൾ ചിലപ്പോൾ നമുക്ക് ഒരു പ്രതീക്ഷയുമില്ലാത്ത കേസിൽ, നമുക്കറിയാം ഇന്നത്തെ കാലത്ത് ക്രോസ് എക്സാമിൻ ചെയ്തൊരു സാക്ഷിയെ പൊളിക്കുക എന്ന് പറയുന്നത് വളരെ ബുദ്ധിമുട്ടാണ് കണ്ടസ്റ്റിംഗ് കേസുകളിൽ. അപ്പം പ്രത്യേകിച്ച് പോക്സോ പോലെയുള്ള ഒഫൻസിലൊക്കെ. അപ്പം ചിലർ പെട്ടെന്ന് ക്വസ്റ്റ്യൻസൊക്കെ ഫ്രെയിം ചെയ്ത് പെട്ടെന്ന് ചോദിക്കും. അത് നമ്മൾ കേട്ടിരുന്നാലേ നമുക്ക് പിടികിട്ടുള്ളൂ. പിന്നെ എനിക്ക് തോന്നുന്ന ഈ ലീഡിങ് ലോയേഴ്സ് ഇപ്പോൾ ട്രയൽ സൈഡിൽ നമ്മുടെ ഇപ്പോൾ കേരളത്തിലുള്ളവരാണേലും അവർ 161 വളരെ തറവാണ്. അതിനകത്തുനിന്നൊരു സാക്ഷി അങ്ങോട്ടോ ഇങ്ങോട്ടോ ഡീവിയേറ്റ് ചെയ്ത് പോയാൽ അന്നേരം അവരത് ഒമിഷൻ ആണെങ്കിലും കോൺട്രഡിക്ഷൻ ആണെങ്കിലും മൈനറാ പലതും. എന്നാലും അവരത്ര 161 നല്ല കാണാപ്പാടം പഠിച്ചു കഴിഞ്ഞാൽ ക്രോസ് എക്സാമിനേഷൻ വളരെ എളുപ്പമാണ്. ഇടയ്ക്കുന്ന് അങ്ങോട്ടോ ഇങ്ങോട്ടോ മാറിയാൽ നമുക്ക് ചോദിക്കാൻ വളരെ എളുപ്പമാണ്. 161 ഇപ്പോൾ അബ്കാരി കേസാണെങ്കിലും NDPS കേസ് ആണെങ്കിലും ഇവൻ്റെ 161 ഈ ഇൻവെസ്റ്റിഗേറ്റിംഗ് ഓഫീസറുടെ സ്റ്റേറ്റ്മെൻറ്റ്, കൂടെ ഉണ്ടായിരുന്നവരുടെ സ്റ്റേറ്റ്മെൻറ്റൊക്കെ നല്ലപോലെ നമ്മൾ അറിയാമെങ്കിൽ കോൺട്രഡിക്റ്റ് ചെയ്യാനൊക്കെ വളരെ എളുപ്പമാണ്.
ചോദിക്കുന്നത് ശരിയാണെന്നറിയില്ല. മറ്റേ 80 പറഞ്ഞല്ലോ, 164 അഡ്മിസിബിൾ ആണ്. നമ്മൾ ഡോക്യുമെന്റ്സിന്റെ കാര്യത്തിൽ പക്ഷെ അത് അതെ അപ്പീലിൽ വരുമ്പോൾ എന്ന് പറയും, അതായത് 80 പ്രിസംഷൻ അനുസരിച്ച് സാധാരണ ഒരു ഡോക്യുമെന്റ് ആകുമ്പോൾ നമ്മൾ 2 കാര്യം പ്രൂവ് ചെയ്യണം. ഒന്ന് അതിന്റെ ജെന്യൂനെസ്, പിന്നെ രണ്ടാമത്തേത് കോണ്ടന്റ്സ്. അത് സെക്ഷൻ 80. പക്ഷെ 164 സർ നേരത്തെ പറഞ്ഞ എക്സാമ്പിൾ അനുസരിച്ചിട്ടാകുമ്പോൾ വരില്ലല്ലോ. അതെ
അതായത് 164 കണ്ടന്റ്സ് പ്രൂവ്ഡ് ആവുകയാണ്. ഇറ്റ് ഈസ് ഡ്യൂലി റെക്കോർഡഡ് എന്നുള്ളൂ. അതിന്റെ ട്രൂത്ത്നെസ് പിന്നീട് ഇൻഡിപെൻഡന്റ് ആയിട്ട് തീരുമാനിക്കണം. ട്രൂത്ത്ഫുൾനെസ് ഓർ അതർവൈസ് ഹാസ് ടു ബി ഡിസൈഡഡ് ഇൻഡിപെൻഡന്റ്ലി. അതിപ്പോ ഏത് കേസിലാണല്ലോ അങ്ങനെയാണല്ലോ. ഒരു സാക്ഷി പറയുന്നതാണേലും അവൻ പറയുന്നത് നമ്മൾ അതേപടി നമുക്ക് സോൾവ് ചെയ്യാൻ പറ്റില്ലല്ലോ.
പക്ഷെ അങ്ങനെ വരുമ്പോ ഈ 164ന്റെ കണ്ടന്റ്സ്
അവൻ അങ്ങനെ പറഞ്ഞിരുന്നു എന്നുള്ളത് വരെ പറ്റുന്ന സുപ്രീം കോടതി പറയുന്നത്. ബിക്കോസ് ഇറ്റ് ഈസ് റെക്കോർഡഡ് ബൈ എ മജിസ്ട്രേറ്റ്.
അല്ലാതെ അത്
കോൺട്രഡിക്ഷൻ ആണ്. അത് ആ കോൺട്രഡിക്ഷൻ ഹൈലൈറ്റ് ചെയ്താൽ മതി. അതായത് അത് ചോദിക്കേണ്ട കാര്യമില്ല സാക്ഷിയോട്. നിങ്ങൾ മജിസ്ട്രേറ്റിനോട് മൊഴി കൊടുത്തപ്പോൾ പിച്ചാത്തി കൊണ്ട് കുത്തിയെന്നല്ലേ പറഞ്ഞതെന്ന് ഞാൻ അത് ചോദിക്കണ്ട. 164 എടുത്ത് വാദിച്ചാൽ മതി. 154 അത് പറ്റി. Okay.
Sir, we have one more formality. I invite Advocate Sarath KP for delivering the vote of thanks.
So one last. So good evening, everyone. So Honorable Justice Jobin Sebastin sir and other senior lawyers and dear friends and lawyers. So it's my privilege to say vote of thanks for this occasion. And first and foremost, I would like to thank Justice Jobin Sebastin sir for coming to our function and and delivering such a wonderful lecture. So when we start discussing about organizing, starting a criminal law lecture series, unanimously everyone in the Wednesday Club suggested sir's name. And when we approached him, he readily agreed to it. So we all are, as part of our family, we thanking you, sir, for coming here and giving such a wonderful lecture to all of us. And also, I'm taking this opportunity to thank our welcome speaker. I know I don't need to separately thank Peeyus sir, but as a matter of formality, I'm thanking him. Not only for this function, but continuously he's extending all the support to us. So I'm thanking him for all the constant support given to Wednesday Club. And also here Vinay sir is here and Secretary Nima madam is here. So everyone extended their whole support to the Wednesday Club, not only for this function, but all the programs we conducted so far. So I'm extending my thanks to them also. And for this program, there is a group of advocates who work behind. So I really want to mention their name. It starts from Hamdan Mansoor, Akash, Cherian Thomas, Jeni John, Sebastian, and Navaneeth Gopan, and Meena. So all of them work together, and also Uttara and Haroon, Ashraf. So there's a bad team work behind this. I want to take this opportunity to thank each of them. Also Anjali Chichi, Ruben Chetan and Subish, all those who are part of Wednesday Club knows them really well because they were behind all the programs. So I wanted to take this opportunity to thank them also. And not the last, I wanted to thank the staff of our association because they are also supporting us for all the matters. They are supporting us. So I am taking this opportunity to thank all of them and all the participants who came here, all the senior lawyers who came here. I am taking this opportunity to thank each and every one of you for making this program a successful one. Thank you so much.
With this, we have come to the end of today's session. Thank you, everyone.
Bye,